on the slopes of Diamond Head. This is Kapiolani Community College. Kulia ika nu'u, strive for the highest.
Aloha. Welcome to BLAW200, Legal Environment of Business. My name's Ben Carroll. Last time we wrapped up our study of torts, so we looked at those rights. Today we're going to take a look at some additional rights, and we call them intellectual property rights, and I think you'll find that quite interesting as well. But as always, first we'll start with our review. Okay, to prove negligence, what must be shown? Remember, those were the four elements. Need to show a duty, a breach of the duty, in other words, a failure to do the duty, which actually causes legal causation and factual causation injury. Okay? What are some of the defenses to negligence? Well, there's comparative negligence, which compares the negligence of the person injured with the tortfeasor. There's assumption of risk, where you've assumed some risks. There's last clear chance, and there may be some intervening causes, something that came between your cause of the injury and the injury. Who does the law consider to be a reasonable person? Well, you remember this isn't our average person. This is a hypothetical person the law has created. And this person is attentive, aware of their environment, honest, etc. So we hold this person up to judge how the rest of us act. And are professionals or experts held to the same standard? No, when they're practicing their profession, they're held to a professional standard, so they are expected to operate as a reasonable professional would. And we call this, remember, we call professional negligence, we call that malpractice. Okay, what is being compared in comparative negligence? Again, we're comparing the negligence of the wrongdoer, the tortfeasor, or the defendants, with the person that was injured, who is generally the plaintiff. So we're weighing the amount of negligence each of those did. And you recall that we sometimes put this in a percentage, and that will show up in our damages. What does assumption of risk mean? Again, these risks are those that are inherent in the activity. So if you're deep sea diving, you understand the environment that you're in, that there can be changes in currents, there can be wild beasts, etc. And those are part of the activity. It doesn't mean that you assume the risk of negligence. So if somebody fills your tank improperly with nitrogen instead of oxygen, you have not assumed that risk. You've only assumed the risks that are inherent in the activity itself. Okay, Good Samaritan law. Good Samaritan law is a law that is meant to shield people who are attempting to assist others. So if you try and help someone and you are negligent, you may be protected. If you are grossly negligent or reckless, not so much, but it will protect you and encourage you to assist others. Dram Shop Act. You recall this, dram shop's just an ancient word for liquor establishments, so this means that you can be liable if you serve someone who should not be served and they later injure someone. So this is, again, part of our vicarious liability, where we can be liable for something someone else does. In actuality, we're liable for our own negligence in serving this person. Okay, how does strict liability differ from negligence? Well, negligence is based on fault, so our failure to do our duty, our breach of our duty, is fault. Strict liability or absolute liability is also called liability without fault. So for certain activities, it doesn't matter how careful you are, you may still be liable if doing that activity causes injuries. And in common law, what was covered? Well, these were essentially keeping wild animals and using explosives were considered to be abnormally dangerous, and you would be liable regardless of how careful you were. Okay, possible grounds for product liability suit. Well, the normal liability of negligence, also strict liability for producing defects, and also warranty, which are promises, and we'll talk about those more when we talk about sales. And finally, differing positions on the need for and effect for tort reform. Well, you heard from some folks on this, and it's a continuing debate. There's more things on the website about the tort reform. It comes up every few years. Okay then, today we're going to get into intellectual property. Okay, so what is intellectual property? Well, property of the intellect, and it includes patents, copyright, and trademark. Some people will also add trade secrets to that, and this is a rapidly developing area of the law, particularly with the internet and international things going on. So we'll take a brief look at that as well. Okay, so what is intellectual property? Property rights which come from the creation of the mind, the intellect, and this generally gives you the right to exploit your property, something you've created, or to authorize others. And the way it's set up in the United States is we want to encourage creation, but we also want to encourage that creativity in those products that are created. We want to get those into the public stream of commerce. So we will typically provide this protection for a while, and then it will be opened up to the public. Okay, so the major types are patents. We think of patents when we think of invention. So you've created a device or something that you need to patent so that you can receive the benefit of having created it. And nowadays, some of these creations, it costs a lot in research and development, and so it makes sense to provide some return on that for the person who's done that. Copyrights is probably the one you're most familiar with, and we think of copyrights as being written works. It's actually works in any fixed form. We'll talk about that. And these are thought to be artistic and literary type of works for the most part. Trademarks. Again, you see this all the time. Trademarks are all over the place. This is an increasing part of marketing and modern selling. And so any marks that are used to indicate your origin and your company will be a trademark or a service mark if you're talking about a service. And finally, trade secrets, certain things that are secrets of your particular business, and as long as they're secret, they receive protection as well. Okay, so what's the rationale for what's the reason and purpose for intellectual property? It's, again, an incentive for people to create things and to go out on a limb, do research, try new things, and make these products available. The other thought is that if you've created something, you should be the one that mostly benefits from that. But it is a balance between protecting an individual's creativity and also the public interest in learning new things. For example, the first person who invented a wheel, if they were able to patent that, then for many years we would be dragging things around. So you can see it makes sense to eventually get that into the public knowledge, the public realm. Okay, the source of IP rights. Well, the Constitution provides for both patents and copyright. So it was felt that there was a need for uniformity across the country. It was a new country. We were developing things, new ways of doing things. And so the Constitution provided this, and it emphasizes that this is the benefit for the public good. So it really talks about this is useful things that we want to have available so we can progress. Okay, in addition to the Constitution, we also have some federal statutes. Each of our areas has a federal statute, and certainly in patent and copyright, most of our work is federal. With respect to the trademark area, there's a lot of state and common law background to this, although we do register those federally so that we can make sure that we're covered in the rest of the country. And then, of course, there's some common law underpinnings And you can obviously do a lot of this type of thing by contract. Okay, we'll talk about licensing as well. Okay, so if we look at the different elements, and patents, copyright, and trademarks have some very unique and distinct features as well, but there's some generalities we can make. So first thing we need to look at is what kind of subject is covered. How do you qualify to get that protection? In other words, who can claim it? What you have to do actually to get the protection of the law? And what kind of rights does that give you? What does your protection allow you to do? And what are some of the limitations on those rights? Then we'll talk about infringement. And by infringement, we mean someone else is violating your intellectual property rights. And then we'll talk about what the remedies are. And the remedies are quite similar. There are, again, some unique features, but the remedies are quite similar. As you can imagine, one of the remedies would be to prevent the people from violating. Okay, so what is a patent? Well, a patent is recognition that you have created something that is new, useful, and non-obvious. So we're looking for a utility here. We're looking for something that, again, advances knowledge, advances progress. And it's a trade-off about disclosing this, and then for a limited time, you are the only one that can use it. So with a patent, we do actually disclose what we've come up with, and then we are able to have exclusive use of that for a period of time. And this is one of the shortest periods. This is 20 years. So when we patent something, we have that patent for 20 years. There is an ability to extend it, for example, generally in pharmaceuticals. Part of this is because it takes a while to actually get the patent, but it is a fairly short time period that this protection is effective. The right is really the right to exclude others from using this new invention. And so it doesn't necessarily give us the right to produce it. And that's kind of sounds a little strange to us, but if we get a patent, it doesn't mean we can create this thing. It means we can keep someone else from creating it. So what is that all about? Well, we may do an improvement. You hear about the mousetrap. If we have a new and improvement on a mousetrap, it may be something added to that product, but there's still a patent on the original. So we can't produce the new and improved since it might violate the patent of the person that created the original. So they, on the other hand, they can't use our improvement. So you can imagine what generally happens is we'll license or we'll come to an agreement, but it doesn't give us the right to produce it just to prevent someone else from doing it. And the other example might be if you create a new designer drug, the fact that you have patented it doesn't somehow mean you can produce it because it's still illegal. Okay, so the patent gives us a right to prevent others from using our invention. Okay, what can we patent? Well, the terms you'll see all the time are anything under the sun made by the hands of man. So what is that talking about? Well, for the most part, we can't patent life. We'll talk about that in a minute, but we can't patent something that occurs naturally. So we're talking about methods, products, apparatus. Composition of matter is simply new formulations, alloys, that sort of thing. Design for articles of commerce is oftentimes the appearance of something. And in certain cases, we can do a plant. If we do a hybrid or something, we create a new type of orchid. Okay. What can't we patent? Well, you can't patent ideas, and we'll see this in copyright as well. So a pure idea you cannot copyright. You can't occur things that occur in nature. Okay. You can't patent a way of doing business. Okay. Something like look and feel. So if there are different ways of creating this appearance, normally you couldn't patent that, for example, like a spreadsheet. And the other problem is, although we disclose our patent once we've gotten it, we disclose our invention, the government actually does that. If it's disclosed before we get our patent, we may have a problem because then it's already out there. So there are some limitations. We have to apply for our patent fairly quickly. Okay, so just a brief look at our patent timeline. You get an idea, you need to file within a year of it becoming public, and then it will take about 18 months for that patent to occur. Okay? Then they will publish it, so at that point people will know about your idea, and then they will issue the patent. And this can take, as you can see, 2 or 3 years, and then you only have 17 years left of your patent. So you will need to, in essence, make your money back during that period that your patent is in existence. So what does a patent look like? This is just what they appear, fancy with all the seal and the ribbons. That's what your patent would look like. And the application's fairly involved, so you would be including, you can see, schematics, drawings, complete explanation of what your patent looks like. So you can probably detect from this that you're going to need help in filing a patent, and the patent is a fairly specialized area. It's not nearly as user-friendly, for example, as copyright. Okay, so we'll look at a few of the things that are unique about patents. It has longest application period, as we saw. It takes you a couple years to get this, and that's why you sometimes see patent pending, so you're putting people on notice that this lengthy process is going on. It's quite specialized, as I indicated, so you may need the assistance of a patent attorney. That's kind of a very special area. Not every attorney is authorized to get involved in this. After the patent expires, anybody can produce this. So you've all seen generic drugs. So that means that when you have Tylenol, when that was first created and the patent was issued, that particular manufacturer was the only one that could produce Tylenol. After the patent expires, anybody can produce it. Now, can they use the word Tylenol? No, that's protected by copyright, trademark, etc., some other IP areas, but they can certainly produce the drug, and so that now occurs in many, many formulations. So you hear the generic names now of things like ibuprofen, the statins, drugs, those sorts of things. Anybody can produce those now. Those are now generic. But again, can't use the original titles because those are protected by other IP areas. Okay. Let's get to copyright. Copyright is one that we're most familiar with. Protects original literary, dramatic, musical, artistic works and derivative works of those. Again, like the patent, you can't copyright so much an idea or a concept. Okay, but you can copyright the expression of it. So the way you formulate it, the words you use, the picture you use, that you can copyright. But the idea, so if you have a little girl going down a rabbit hole, you can't copyright that. If you have a talking mouse, you can't copyright that. Now, particular expressions, yes. Okay. Now, there are much longer protection here, so currently it's valid for the life of the author plus 70 years. So the person who creates it has a copyright during their life, and their heirs or assigns or whoever has the rights have it for an additional 70 years after that. And this has changed dramatically. Certainly there's some suggestion that people with powerful people with copyright, such as some of the movies or Walt Disney or whatever, have been involved in extending the length of the copyright. Again, there's some other time periods here. We talk about works for hire, which means that you create something while you're working for a company, or you're paid to create that. And so there may be some different periods here. Okay, so what does it cover? It covers the right to reproduce, prepare derivative works, in other words, sequels, etc., distribute, perform, and display. Now, the interesting thing about copyright is it has strong common law background, and the actual Copyright Act has adopted or made statutory the common law. But you have a copyright from the moment you put something in a fixed form. So as soon as you write it, you have a copyright. As soon as you sing it in its fixed form, you have a copyright. So it's instant. You don't have to put a C, you don't have to register it any place. You have a copyright in that particular work. Okay. Now, we talk about perfecting your right. So that's making your right public, that's making your right more protected. And you do some other things for that, like putting people on notice and registering it with the Copyright Office. But the copyright itself, you have from the moment it's created, as soon as you put it in fixed form. Okay, so again, the notice is optional, certainly advisable. There's a number of ways to do that, and you've seen those. You can see the little C in a circle. You can put copyright, etc. And normally you would want to put both the date, put people on notice, and your name or a name that can be associated with it as the copyright holder. Now, some countries also will provide additional protection if you put all rights reserved. So you may see that, my understanding is particularly South America, saying all rights reserved is helpful. Because again, the laws we're talking about are national laws. We'll talk a little bit about the international implications as well. Okay, now copyright registration, as we talked about, is not required, but if you register your copyright, this allows you to pursue infringers, people who have violated it, and it also provides you with additional protections. So if you have registered it, then there are what we call statutory damages in addition to any actual losses you have, and you are able to obtain your attorney's fees. So registration is a good bet. Copyright registration is quite inexpensive, and also it's easy enough to do that a lot of people can do this themselves if they do a little homework and get familiar with it. So it probably, if you have something that you think has got some legs to it, and not just a term paper, but something you've created that you expect to be income producing, it's worth your while to register it. Okay, now you've heard of the public domain, and particularly with the internet happening, people think of a lot of things as being public domain. But what does that mean? Well, domain means kind of the ownership area, so public would mean this is something that anybody can use. Now, copyright has a lot of mythology about it, and so let's take a look at what we mean by public domain. So how does it end up in the public domain? Well, either it doesn't have any copyright attached to it, and that would be true of many government works, or the copyright has expired, in other words, the 70 years or whatever it was at the time has passed, or the author has relinquished it or said, is this okay to be used by anyone? I put this into the public domain. Once it's in the public domain, it has no copyright protection. You can do anything with it. So it's like nobody owns it, or the public owns it. So you can do it with it as you will. So in the United States, everything published before 1923 is in the public domain. So you have older works, Shakespeare, etc. These things are in the public domain. And the other major category in the public domain is U.S. federal works. So federal publications, etc., for the most part are in the public domain. Now, there may be some exceptions if the feds have obtained rights from someone else. They may still have some minor areas, but certainly most of the government publications, most of the things on government websites are not protected by copyright. Okay, another area we want to be clear on, we'll spend a little time with this, is fair use. So you've probably heard of the fair use doctrine, sometimes misspoken as free use, not free use, but fair use. And this is material that is copyrighted, but you have the ability for some limited use of this without the owner's permission. Okay, so you have to keep yourself within the boundaries of what's considered fair use, and if so, you can use it without the permission. In other words, a copyright owner may not want you to use it, but if you fall within fair use, you are able to without permission. And this is for public type of purposes, so it's for criticism, comment, parody, news reporting, teaching, research, academic type of things. And so we typically see that a lot in the universities, is we are able to use certain things in a limited way for teaching. Okay, and again, news reporting, or if you're criticizing something, makes sense you would be able to refer to the work that you're talking about. Okay, so we'll look at these criteria briefly. So the criteria are about the purpose of the use, nature of the original work, the amount you're using, and most importantly, how that's affecting the ownership rights of the copyright holder. Is that impacting them financially? So let's do a kind of quick look at these elements. So the character of the use, and you can see we'll look at these 4 of these charts, and on the left side, you will see that this is likely to be fair use, and as you move the other direction, that's where it may take you out of fair use. So certainly, if you're using it for a private reason or you're using it to teach, that's different than if you're trying to use it to make money yourself. So that would be more nearly violating their copyright holders' rights. If we look at the nature of the work, okay, if this is something that's already out there, already published, then that's more likely to be fair use. So for example, if we're using a newspaper story. If it's not published, if it's more in the imagining nature, more in the creative side, then that would be less likely to be fair use. So if we've got somebody's notes that they're using to make a play, that would be less likely to be fair use than if, on the other hand, we have a newspaper story and we're just referring to a news story. Okay. How much of the work will be used? Well, this is kind of common sense. If we use just a little bit of the work, for example, we're doing a review of a play and we just talk about a few of the things there, that's much different than if we use more than that. So we're using a big chunk. So if I wanted to refer to something in a published work, and I just said, here's a paragraph to give you an idea of what the person's saying, that's different than if I tried to use a whole chapter of a book, to say, well, this is a good rendition of the subject. Let's check out this chapter or this whole article. Okay. Obviously, it depends on the length of the work. So if we had the Iliad and the Odyssey and I gave you 13 lines, no problem. If it's a sonnet of Shakespeare, or, well, I forget, is that 13 lines? But if I gave you the whole poem, same size, but the part of the work is obviously much, much different. And finally, this is the critical criteria that they'll look at. What is the effect that you're having on the rights or the market of the original? So if I give you a news article, which I've done on the sites, that's not likely to affect your desire to purchase the newspaper, cancel your subscription if I give you a single article out of a single issue of a newspaper. However, if I give you a chapter of a book, and that's the only chapter we're interested in that entire book, you're not going to buy the book. So that's a very important thing, is what does it do to the market? What does it do to the copyright holders' rights and income? Okay, so what are some alternatives to copyright? Well, what generally happens is these things can be licensed. So we can allow different uses of works by licensing that use and specifying what uses are okay. And this happens quite a bit, particularly in academic circles, where we'll say it's okay to use this in a non-commercial way if you're a nonprofit, if you're a teacher, but you are not permitted to use this for commercial purposes, so you can't be making money off of my copyright. So licenses allow us to specify this. And there's a whole lot of movements going on here. You may have heard of Creative Commons, and this is specific licensing that says you can use it in these ways. If you give me attribution, if you use my name, if you're using it just in this way, etc. So on the website, there's some explanations of Creative Commons. It's gaining a lot of popularity. It's what they call copyleft. And again, this is licensing, but they're making a play on words, obviously. And this has to do with, again, specifying the rights, and then if you use it and you improve it, you have to offer it to the public in the same way. Okay, so this is ways of getting around sharing in a legal way. There's also Massachusetts Institute of Technology has free courseware, so they have people have said, here are some courses and here are some materials. We're putting those out for the public. Okay, so some people are putting things into the public domain, in other words, relinquishing copyright entirely, and some people are retaining copyright, but they're licensing it in a way that's very, very open, and in many ways, as long as you follow some set specs that they give you, it operates in a lot of the same way as public domain. You can use it in a lot of different ways. Okay. And again, there's more information on that. It's a very growing area. Okay, so just a quick look at the spectrum. Copyright, you can retain all rights reserved. That means that nobody can use that without getting your permission and licensing it, okay, until such time as it expires. And on the other side, there's public domain, and that is something that has no copyright protection. And the things we've talked about are the ones in between, where through licensing we have reserved some rights, although can be very, very open. Okay, so let's take a quick look at these pictures, and then we'll talk about them a little bit. So you'll see what we call the Scream, and this is by an artist named Munch, quite famous. You can see Happy Birthday. And finally, you can see The Thinker by Auguste Rodin, a French sculptor. So, are these subject to copyright? Well, what's the first question you might ask is, when were they made? That makes a difference. So, copyright what? If they're before 1923, then we probably don't have a problem in the United States. But we may have issues in other countries, and we'll talk briefly about that. But, for example, The Scream by Munch, you see that all over the place now. That was produced before 1923. And yet, in Scandinavia, some of the countries, it's still protected for some more years. Okay. Now, the Rodin statue, that was, again, pre-1923, so we can make copies and that sort of thing of that. We probably don't have a problem. Okay. How about Happy Birthday? Some of you may have heard about this. Happy Birthday is still under copyright. So if you sing Happy Birthday, you are using a copyrighted song. Again, there's some disputes about this, whether it was lost or not, but in general, people still acknowledge that for a few more years, Happy Birthday, the song, is in fact subject to copyright. And so when it's used in movies, the movies are paying for the right to sing Happy Birthday on screen. Okay. Now, somebody going to come after you at your child's birthday party? No, they're not interested in chasing around individuals. But certainly, if it's done for profit, done on air, it is still being paid for. Okay, so kind of interesting. One final point is, I have given you here pictures of pictures. Okay, so I can use the idea of the Scream, but I have given you a picture of that painting. It may be that the picture of the painting is copyrighted. If somebody took this picture and put it on the internet, they aren't necessarily giving me the right to use their picture of the picture. Same thing with the statue. The picture itself, the photograph of the statue, may be subject to copyright. So you can imagine museum brochures, things we find on the internet, there may be a copyright of the photograph of something that is no longer subject to copyright. So different levels here. We'll talk about using things you find on the internet. There's some concerns with that. Okay, so what's unique about copyright? Well, it's protected upon creation. In other words, it's like instantaneous once you put it into fixed form. So you don't necessarily need notice or registration, which you would need with the other forms, but there are some reasons to do that because of your remedies. Okay. It's relatively inexpensive to get a registration, so if you have something you think has some commercial value, you certainly would want to do that. This is the area that's been very greatly impacted by internet because all sorts of things are now on the internet. People kind of have the idea that, well, if it's on the internet, I can use it. But over the last few years, you'll notice even Google Images, every one they put up, they say may be subject to copyright because that is in fact the case. And there's a lot of public myths and misconceptions about what you can use and can't use. And on the La Lima website, we have some exercises about what the myths are and what the realities are. So you can get a little deeper into that. Okay, we come to trademark. Trademark is pervasive. So we're talking about a distinctive word, name, symbol, or device, or any kind of combination. So a lot of times we think of trademark as as a picture or an image, but it includes names, etc. It distinguishes the origin, so it tells us where it came from, and it also distinguishes this product from other products. So it's kind of a shortcut to recognizing something. You see it and right away that came from wherever. And originally it was meant to maintain quality. In other words, you know that this sword was made by Olaf, the sword maker. You liked his sword, so you were sure, seeing his mark, that he had created that, and you wouldn't be confused if someone else was creating swords that look kind of like that. Okay. Nowadays, a large part of the value of the trademark is the goodwill or the reputation that's been built up. So certainly in marketing, it has a very serious value. It's not just about mistaking identity now. It's more than that. Okay. Now, the TM, the trademark, is a kind of a no trespassing sign. It's kind of like the C, and you can put that on things. It's kind of like the copyright mark. But if you use the R, you can only do that when it has federal registration. So that indicates that you have registered it as a trademark with the federal office, and it's illegal to put the R on until you've done that. Okay, so we have some well-known trademarks. I suspect almost everyone knows what they are. And you can see that the M and the Y are simply letters, but they're distinctively done so that nobody's going to confuse whether or not we're talking about McDonald's and Yahoo. Okay, the apple with a bite out of it, sometimes you see it with a rainbow, sometimes you may see it metallic silver, but just the shape itself pretty much tells you who we're talking about. And what has a computer company got to do with an apple? Nothing. But that is a very distinctive mark, and it's maintained an ability to tell us who that is. Again, the 5 interlocked rings, doesn't really matter whether they're colored or not. We know what that means. What do the 5 rings mean? Many people don't know. It's continents, but we do know for the most part that means the Olympics. So these are different kinds of trademarks. Some of them are use the letter that related to the name. Some do not. Some have nothing to do by appearance with the product. So we have different varieties of trademarks, whether they are what we call descriptive, which means that we need to over time develop an association, or they can be totally fanciful, like an Apple or a name like Exxon that has nothing to do with the product. And those are easier to develop as your trademark because you're not using something descriptive that could apply to other people's products as well. Okay, just a quick look. Here we can see we got the exact same letter, but many people will recognize one or more of these as being a particular company, even though we really just have a letter. So I think most of you will recognize the slanted Kellogg's K. If we have a K in a circle, there's a Circle K convenience store. And the yellow K used to be the major company in that field. That's the Kodak K. And you probably recognize the Kmart K as well. So you can see we take the same letter, but we do some different things to it, color, shape, etc. And it acquires a meaning that's well known to many, many people. Okay, so what can we use as trademarks? Well, we can use some unusual things as trademarks as well. So again, we think of symbols and that sort of thing, but we can also actually use a color. So they have actually recognized that fiberglass insulation that is pink automatically means it's Owens Corning. So nobody else can use pink for their insulation. Okay. How about the movies, MGM movies? That particular lion's roar is MGM's. Nobody else can use that. Okay, the old shape of the Coke bottle. Okay, only Coke could use that. And here's a developing area. There's a cherry scent for racing lubricant. I'm not sure that it's actually out now, but a patent was issued for scent for racing lubricant. Now, could you use a scent? Could you trademark or a scent for plumeria perfume? No, because there's many, many plumeria perfumes, but not too many up to this point. Racing lubricants didn't have a scent, so you could do that. Okay, these kind of attributes, again, need to get secondary meaning. In other words, the meaning now is attached when you smell a racing lubricant that is cherry flavored, you know that's that particular one. If you see fiberglass insulation that's pink, you know it's Owens Corning. So it now has a meaning over and above simply the color or the scent, that sort of thing. Okay, what's unique about trademarks? Well, trademarks are not based on the Constitution. You saw that we had a constitutional reference to both copyright and patent. Trademarks were not recognized in the Constitution, so they've mostly developed from common law, and it's mostly been on the state side. Now, interestingly, if you use your trademark and you keep it registered, it does not expire ever. So we have companies and logos and things from 100 years ago, and these will continue on as long as they're properly used and aren't lost by either failure to register or failure to use. Okay. Again, there's differing varieties. We talked about descriptive, so when we talk about descriptive trademarks, we're simply talking about something that describes something. So you couldn't call something certain kind of apple by red apples. That couldn't be trademarked because it applies to everything. It merely describes. Sometimes something descriptive can acquire secondary meaning, but it's quite hard. So it's hard to do these things that are simply descriptive. Now, something suggestive, you may be able to do that. For example, if you said sudsy laundromat. Okay, so that's suggestive. You may be able to use that. Okay. How about something very arbitrary? And when we think of very arbitrary, we're thinking about Apple computers. So what has computers got to do with apples? Nothing. So if we say Apple computers, that can acquire that meaning, and that can be very, very strong. And perhaps the strongest is something that we consider to be completely fanciful, a made-up name. So we have Exxon. Where did they get that? What does that mean? Well, it means until it gets the meaning attaches to it, doesn't mean anything. So more and more we're getting those kinds of terms where they just stick in your mind, but they have no meaning other than referring you to that product. And that's a very strong association. Okay. Now, once you get these names that, particularly the strong, fanciful kinds of names, you need to protect those names. And it's very critical. If you do not, it may become generic. So if everybody starts using the name of your product to cover a whole bunch of products, you can be in trouble, and it's called genericization, and you can lose your trademark that way. And this has happened many times. So, for example, many people do not know that aspirin used to be a trade name. Bayer owned aspirin. Now, any aspirin is an aspirin. They lost it. And this happened many times. I'll just give you a couple of these that you can see how powerful this product was. It is so much represented the field that it eventually became the name for that kind of product, and the manufacturers lost the ability to have only their product with that name. So it went from being a trade name to now being a description. Okay, even though originally it didn't describe anything. It was a new name. It was a trade name. Butterscotch. Butterscotch was originally a name of a Parkinson's company. Okay. Escalator. Originally, only Otis made escalators. Any other moving stairs had to be called moving stairs or something else. Heroin. Bayer also had the name heroin. Kerosene. Phillips head screwdrivers, named after Phillips. Pogo sticks, originally a brand name. Thermos, originally a brand name. Yo-yo and zipper. So you can see these are names we now use all the time. Originally, only one company could produce that, and someone else would have had to have a different name, some kind of closure for their zipper. But now they have lost those. They've now become generic names. There's a number of companies that came close to this, but they protected it. They pursued infringement, and so they now kept those names as being only their product. One of them is Kleenex. Used to be people would ask for a Kleenex, and they were talking about something made by Scott or a paper company, someone else. Kleenex went after them, so Kleenex has retained its name. It's retained the name. Xerox. We used to talk about a Xerox machine when we meant any kind of copier, and Xerox went after that. Plexiglass. A lot of us still will use these terms when we mean product, transparent plastic glass substitute, but plexiglass almost became generic and didn't. So they went after them and retained it. So you can see, if you have a good name, you need to protect it. So you do need to go after people. Okay, so what are the remedies we have if we have our intellectual property infringed? So the main remedy we already hinted at is the injunctive. So you will go after people and you will say, stop using our name, stop using our product, stop violating our trademark, etc. So that's our key remedy, is to stop the use that's violating us. Okay. We can also get damages. In other words, we had losses, we've lost sales, etc. And in some instances, there will be statutory damages that are more than just our actual losses. And again, we talked about copyright, where to get those you need to have registered. Okay. Other thing would be attorney's fees. It will cost us to pursue the infringement, so we can get an award of attorney's fees. In some of the areas, copyright and trademark, if someone has made profit off of our intellectual property, then we can go after their properties. With a patent, we can get royalties. In other words, they need to pay us for that use. And in copyright, we can impound violating material. So if somebody produces books that violate our copyright, they can impound those materials. Now, again, talking a little bit while about the problems with the internet, but you can't impound really on the internet. So that's an issue now that his technology has changed, whereas before, with books being published, we could stop the process, etc. And you recall, we talked about this when we talked about things like defamation as well. So now that the things are in the ethosphere, in cyberspace, much harder to deal with both torts, contracts, and these kinds of issues, because it's out there. It's not in a fixed place. Okay, trade secret. Well, some people think of this more as unfair competition rather than IP, but I've put it in IP because it kind of fits here. And what is a trade secret? Well, it's a formula, pattern, or device that provides commercial advantage. Okay, so you can buy, sell, and license it, and it's going to be your property forever until the secret gets out. If the secret gets out, then you're no longer protected. So that's why we spend a lot of time protecting them. So what are some of the examples? Well, this isn't actually my lunch. This is just kind of some things. Most famous trade secret is the Coca-Cola formula. And I found some facts that may be interesting to you about the Coca-Cola formula. They say that 2 different people have it. It's kept in a locked safe, that sort of thing. It's been there since the 1800s when it was developed in Atlanta. And so Coke formula is considered to be the #1 trade secret, and people sign agreements when they work for Coke that they won't reveal it, that sort of thing. There's something similar. The Colonel, apparently the 15 herbs and spices, the seasonings used for the Colonel's chicken is also another closely guarded secret. Now, again, part of this may be great sales, but on the other hand, there's something about them that seems to be a commercial advantage. So until Coke tried to change its formula and had to go back to it again, considered to be one of the most closely guarded secrets there. Okay, sometimes the violations of these things are obvious, sometimes they're not. Let me continue a little bit on the trade secrets. The use of a trade secret isn't a violation, so it's just stealing it. So if you happen to get the formula some other way, or you devise it on your own, that would not be a problem. So it's the theft of it or the misappropriation. If someone else can come up with it, again, that's not a problem. So we hear the term reverse engineering, and that means if you can take something apart and figure out how it was made, then it's not really a secret. Okay, now certain things about it may be covered by a patent. So if something is patented, you can't recreate it. But if it's more like a trade secret, a formula, if you can break it down and figure out what the spices are or what the ingredients are, okay, then you may be able to reproduce that. Okay, so let's do a summary of our major areas of IP. So we talk about patents. Again, we think of these as being inventions in machines, and it allows us to exclude other people from using it. Okay. Copyright is authorship rights, and then we consider these to be creative, literary, artistic words, and we have the exclusive right to distribute, to make derivative works, things based on them, to perform them, etc. Okay. Trademarks indicate the source of the goods or services, and what we're trying to do here is we're trying to prevent others from acting like us, from pretending to be us. And trade secrets are legally protected secrets, and again, it's the theft rather than the use that's unlawful, and we can reverse engineer to get them. Now, these are some areas that some of you may have a lot of interest in, and there is a lot more published on the website. One of the examples I think is interesting is most of you are familiar with Victoria's Secret that makes women's lingerie. There was a little company, man and his wife and husband and wife in Kentucky that came up with Victor's Secret. His name was Victor, so they were going to produce men's underwear, etc. So what do you think happened here? Well, Victoria's Secret went after, and Victor's Secret no longer is able to use that term. Okay, why are we confusing Victor and Victoria's Secret? Well, it could be. We might think they're related companies. It might take away business from Victoria's Secret. But the other thing was they considered it to be dilution of the value of their name. So it's like piggybacking and making money off someone else's idea. So again, there's some interesting little examples there if you'd like to take a look at those. Okay, again, last few things are the internet is evolving. So we're talking about information rather than products. So there are very few barriers now with the internet to infringing. So we can make copies. You just pull it right off the net. There's some ways they try and protect whether you can right click and copy, but for the most part, anything on the net you can get. Now, does that allow you legally to use? No, it doesn't, but it's certainly easy to get. There's a lot of differing opinions and debates about whether it's okay to share, because if you have a book, you certainly are allowed to give this book to someone else and let them read it. Once you own it, you own it. Okay, so how about if you pull something off the net? If you buy something off the net, an e-book, can you give that to anybody? Can you do it with music? Can you share music? Again, a lot of questions with music, and there's some things on the website about Napster and about pursuing people that share music online. Okay. Again, there's some issues specific to the internet, such as cyber squatting, getting a name you are pretty sure someone else is going to use because it's similar to their name, and obviously piracy is much more easier to accomplish on the net as well. Okay. And finally, international IP. So as we indicated, the rights that we've talked about now are U.S. rights. So there are differing laws in differing places. We talked about the Munch painting. Copyright laws are quite different. Some of these differences have to do with the different legal systems. So remember way back when we talked about the difference between the common law and civil law. Civil codes have what they call moral rights. So these are more extensive than copyright. So these are like the right to attribution, to having your name used, but they're in a sense broader than copyright rights, and so those exist in many civil code countries. We have a lot of international agreements where we're trying to resolve these differing laws. So there's the Berne Convention on Copyright, and there's some things happening with intellectual property rights. Many different groups are trying to promote agreements between countries, but there's still a lot of areas to be resolved. As you can imagine, there's a lot of counterfeiting issues. From what I recently read, China is kind of the capital of what we call bootleg copies of things, and so there are differing views of what should be subject to copyright, patent, trademark in differing countries. And there's some real debates among developing countries about how, with too much patenting and copywriting, etc., that it's reducing in development. It's making it harder for countries to catch up. And again, remember in our Constitution it said we want to advance progress, and there's some questions about the backing off and extending lengths of time and allowing patenting for different things. So there's some real issues between developed and undeveloped countries here. Okay, so these are the criticisms. It is a monopoly. Are we advancing civilization, or are we just protecting private rights? What is that balance? Again, these are getting more and more extended, and they're actually adding criminalization to some of these laws, both internationally and in the U.S. So where it used to be civil matters pursue damages, now if you remove devices that are meant to prevent copying, you have committed a criminal act. So this is kind of upping the ante here. Again, a lot more on the website. Please take a look. I know it's an area of interest to a number of you. So that's our quick rush through intellectual property. Please take a look at the items on the website. And this is Ben Carroll. I will be having my products here, and I will be seeing you next time. Aloha.